I'm Tony Green. I'm the Chief Scientific Officer at Ben Franklin Technology Partners. And here with my colleagues, Sri Sridibhatla and Kate Srinivasan, we are pleased to present another workshop for the benefit of those in the innovation community. We do this a couple of times a year. It is to be noted that the funding for these workshops comes from a grant from the U.S. Economic Development and Administration for this program PRIMA, and which is designed to work with early stage companies and help match them with resources to help them grow their companies. So we're really pleased this morning to present a very interesting workshop on trade secrets, and we've invited two experts from Fox Rothschild, are one of our sponsors. And so I want to make sure we introduce Eric Reed and Brian Berkley, both of whom are partners at Fox. And they've put together what I think is a really interesting presentation around trade secrets. Not everything needs to be patented or should. The format for this, they will be driving, but I will be moderating any Q&A that comes after their presentation. If you've got questions, please put them in the chat in the Zoom box, and I will grab those and act as moderator to ask the questions of both Brian and Eric. So with that, again, thank you all for participating, and I will turn it now over to Brian and to Eric. Thank you.
Thanks, Tony. Good morning. I hope everyone can see the screen. My name is Eric Reed, and I'm here again with my partner, Brian Berkley. We are both litigators. So with respect to trade secrets, we're the folks who handle the situation when it's gone to a not desirable place, where either your trade secret you suspect has made its way out the door and into the hands of a competitor, or someone has accused you of that. So I litigate a number of things, and I also practice in the white collar criminal investigation space as well. So I have a bit of a different angle on these kinds of issues. Trade secret issues can be both civil lawsuit type matters as well as criminal investigations. And I have actually both of those forms of cases pending right now. Brian?
Eric, I'm a commercial litigator like Eric. I've been litigating trade secret cases throughout my career. Was involved in the first jury trial under the Defend Trade Secrets Act, which is one of the trade secret statutes that we will be discussing today, and teach trade secrets at Rutgers Law School. I find this to be a very interesting area of the law, both from a litigator standpoint, but also from a business standpoint. Oftentimes, as you'll learn through this presentation, as you probably know with your businesses, if you've got trade secrets, they end up being one of, if not the most valuable IP that you have. And so when they are attacked or put at risk, it is very serious. And so it's important to understand the value and understand how to protect them. And that's why we're here today. This slide really gives you a little bit more data points on the point we just made, right? So trade secrets are valuable. The theft of trade secrets has represented about 1 to 3% of US GDP over the years. Surveys of business professionals, particularly executives, show that it's among the most important IP that they have. And from 2016 to 2020, over almost $1.3 billion in damages have been awarded to plaintiffs. That is a very large number over that period of time. And, you know, we give you just an example, a very common one, right? Coca-Cola, its secret sauce, of course, is its secret recipe that it has kept secret for over 100 years. So this gives you a sense that you may already have of how valuable trade secrets can be. So here's the risk. They're valuable, but here's the risk, all right? So 80% of folks recognize, business executives recognize that it's critical to their business. A third have had their trade secrets stolen in the last 10 years that were surveyed, but only a third roughly have adequate trade secret protection. Almost 3/4 expect the risk of trade secret theft to increase. And this is an important point that we're going to discuss throughout this presentation. By far, the lion's share of the theft occurs from insiders, whether they be folks that you've partnered with another business, whether it be a vendor or a consultant, but also most importantly comes from your employees. Former employee leaves with a whole bunch of documents, whether electronically or in paper form. Paper form still happens. And they've got the secret sauce and they go to a competitor and they start competing, taking your customers or using your formula against you. Here's an example of a high stakes trade secret theft. And so Uber had as a truck subsidiary, Otto, that was accused of stealing trade secrets from Google's sub Waymo. And while Uber maintained innocence, it settled the case, providing Google with a $245 million equity stake in Uber. So this number demonstrates to you, how high the stakes can be when it comes to trade secret theft.
And that was one illustration, and this is another. This is a case. This Leopard Solutions case was actually just filed last week or the week before. But Leopard is a data analytics provider for law firms like ours. Law firms subscribe to these services to get all forms of data. And Leopard offered like a free trial period where you can access their data on a trial basis. And one of their competitors thought it would be a great idea to utilize that free trial period to access the database and essentially take everything that they could get. And they copied, at least according to this complaint, the entire database. Now I bring this up really just to illustrate that both the diversity and the types of trade secrets that are potentially out there in terms of what might exist and might qualify as a trade secret, but also to, as Brian mentioned, that their primary risk can be from insiders. This is a situation where the owner of the trade secret allowed the public a certain access to it. And that is one of the risks that we will be talking about is what does it mean to know not only what your trade secret contents are, but also who has access to them. I would expect as this case proceeds, and we're not involved in this case on either side, but I would expect as the case proceeds that there's going to be some serious discussion about how can you claim something as a secret if you let the whole public access it. And the response will likely be that our access is controlled by an access agreement and that it's not our fault and we shouldn't be penalized for people abusing that access agreement. Move on here. Now, so those were a couple of illustrations of what trade secrets might be and how things can go askew. We want to talk a bit about some of the solutions here, what we can do to avoid a lawsuit where you have to pick up the phone and call Brian or call me, and what tools are available, particularly the Defend Trade Secrets Act, which is a federal statute that both defines what trade secrets are and provides remedies for their misappropriation. And the next slide here talks about, again, the DTSA is the Defend Trade Secrets Act, the federal statute. So what's great about this tool, and Brian and I use it all the time, is that there is a really wide and broad scope of what can qualify as a trade secret. It can be any kind of information, really. It could be financial, business, scientific, as you see here. It can be a formula, it can be a process, but the real key is that what you want to claim as a trade secret must actually be a secret. It can't generally be known to the public. It can't be either determined from a reasonable investigation or be something that someone could readily uncover, and we'll talk about that a little bit more. In addition, you as the owner of this, what you would like to call a trade secret, must take reasonable measures to maintain that secrecy. So if you have, in that last example, the issue in that case is going to be whether or not giving the whole world access to your secrets is reasonable. And that will probably be an issue in that litigation. And then the final requirement is that something can only be a trade secret if it derives independent economic value, if there's a value associated with it being secret. Not just that it's something that's useful to your business, but it's useful and valuable to your business because it is secret. As I mentioned, it can be any number of things here. What I would like to point out, though, is this last point, know-how. Know-how is kind of a sticky area of trade secret litigation. And to illustrate that a bit, let's say you bring on someone who you hire as to become a specialist, and you train that person on how to develop your product, and that person knows by virtue of your training things that that person did not know prior to coming on board. So, what are the ins and outs of a particular manufacturing process? What's the right way to dial in a particular way to go about making something? Knowledge that that person did not bring to the table, did not bring to your company, but rather learned as a result of the employment with your company. That can potentially be a trade secret. And Brian and I have litigated cases where know-how is the issue. I resolved one a couple of years ago that involved the manufacturing and development of specialty adhesives. That there are certain processes that have to be followed, and if they're not followed, you don't get the right result. And the argument on the other side was that, well, anyone in this industry knows how to make these things. Not so. And that's what the litigation ends up being about. So know-how is something to keep in mind as a potential trade secret. Brian?
So trade secrets, what are they not, right? So Eric has given a little bit of a flavor of what they are not. And I would point out, I think we make the slides available hopefully afterwards. The couple slides beforehand is really important in terms of the ways in which a trade secret is defined. And so a trade secret is not going to be something that doesn't fit within those definitions, right? You have to keep it a secret. If you're not adequately protecting it, it's not going to be considered a trade secret. Publicly available information. An interesting example of this. So a recent lawsuit was brought by an ex-Blue Jays pitcher from the major leagues against the Houston Astros. He had a game where he played against the Astros and he got lit up, and it was undisputed that in that game the Astros had stolen the signs the catcher was providing to him for each of the pitches, and so he claimed that his whole career got derailed because of that game, and that game was improperly played by the Astros. They stole the signs, which he claimed were a trade secret. The case ultimately was voluntarily dismissed by him, which is a signal that the case didn't have merit. But one of the arguments that the Astros made was that, look, a person seated in the stadium in the right spot with binoculars would have been able to see the signs. And so it doesn't qualify as a trade secret because it was a publicly available, the signs were public available to certain people. Another example of what a trade secret's not, it's something that can be reverse engineered. So if I put a product out into the marketplace, that if someone that doesn't know the trade secret can create that same product, well, then you're not going to be able to claim that what you use to make that product is a trade secret because it can be reverse engineered by the public. Patents are not trade secrets, for a lot of different reasons. The biggest one being obviously the patent is made available to the public and the information about a patent is made available. Another thing that's a bit of a unique nuance point, which is that contractually defined confidential information is not necessarily a trade secret. They can be, but that is defined differently. So think of your non-disclosure agreements that you may have with respect to certain vendors or other business partners that you have. In it, I suspect that you will have a contractually defined term, confidential information, that requires the parties to keep that information protected and not disclosed. Well, that's going to be governed by the way in which it's defined in the contract, not necessarily by the trade secret statutes. Now, it may also qualify as a trade secret, but it also may not. And so it's important for you to understand that those two will be treated differently, because there are oftentimes in the cases a blending of the two.
And I'll give a couple other examples really just to illustrate these points. I handled a trade secret misappropriation case a few years ago for a robotics company. My client, or a guy from the sales team in the client, left. It was employed by a competitor, and my client and that competitor are frequently bidding on the same projects. The same robotics projects. This was to supply robotics for an assembly line for an auto manufacturing application. And my client suspected that this salesperson had stolen what they considered to be trade secrets. And specifically, it was spreadsheets and pricing formulas that they would use in order to formulate their bids for these kinds of projects. And so they lost out on a project that they thought they should have been the low bidder for, to this competitor that was then at that point was employing their former employee. And so we brought suit, and we found out that that former employee had taken a spreadsheet that had embedded in it the formulations for how my client would go about pricing its bids. And this former employee was not exactly a super spy. What he did was just take a flat percentage across the board on every aspect of my client's cost and margin, and just reduced it in order to come in low relative to what he could, with very good knowledge, expect my client's bid to come in at. And so his new employer won the bid, and he's the hero at the new employer until he gets him sued. And that ended up working out our way. My client had appropriate protocols in place. There was not a non-compete in place, or else we would have been enforcing that as well. But even in the absence of a non-compete that would have precluded this person from going to the competitor, he certainly was not allowed to just take what qualified as a trade secret in the form of this pricing and bidding formula and take it to a competitor. And we prevailed in that matter. Let me give you a flip side example. I had another potential client more recently who has an internet-based offering. It's a service-based offering. It's kind of a B2B offering, but it's a startup. And as a startup, maybe does not have as sophisticated or robust internal controls as one might like. And I'm talking to a person who works for this company, and he's telling me about what their great product is and how they go about marketing it and whatnot. And he mentioned something about how the IT structure leaves something to be desired, and explained that the employees don't even have company issued computers, and there's not even a central server, and everyone does their own work on their private computers, where there's no real security in place. And I said, well, that's interesting, because I can tell you what's going to happen if one of your sales guys bolts and has a copy of your customer list and your pricing list and takes that to a competitor, or goes and starts up a competitor. You're going to call me and say, hey, we need to stop this guy. And I'm going to say, well, do you have an agreement? No. Do you have a non-compete? No. Do you have a confidentiality agreement? No. What measures have you taken to secure this information such that I might be able to convince the court that it constitutes a trade secret? And the answer was not much. So they have since changed their ways, but let that be a warning to anyone who might potentially be in that situation. One must make sure one's house is in order to benefit from the trade secrets law. And we will move on, Brian.
So how do you do that, right? So here, we're going to go over some basics. The first basic is defining and classifying what are your trade secrets. Now, this will be unique to your business. Certain businesses are moving so quickly that it's just difficult to define and classify your trade secret today, because tomorrow it may be completely different. And we get that. Nevertheless, it's an exercise it's a critical exercise to engage in an intellectual analysis of determining whether or not you've got trade secrets. What are they? What are the value of them? And figure out what they are and classify them. And if you can do it in a way that will account for changes downstream so that you're not constantly updating it, that would be great. But while there is a debate out there whether or not you should engage in the defining, classifying, generally speaking, in our experience, you should. You should be asking yourself, okay, where do I keep this? How do I protect it? And we'll go over that in a moment. Some strategies, and Eric has already highlighted some. Another important question is, do you index and classify and define your only the most important trade secrets? It depends on how many you have and how much effort there will be. The benefit in doing this, one of the pros is, while there are some basic tools you can use, like a confidentiality agreement, like a non-compete, which we'll go over in a moment, it's also helpful to have very specific protection mechanisms in place that are unique to the trade secret. It helps me argue that you've put a lot of thought and time and effort into protecting this, which also speaks to the value of it and makes our job a lot easier downstream, and also helps you not have to call us, right? Hopefully you're not in the situation where the trade secret has gotten out because you've thought through, okay, what it is, and then you've applied very stringent and specific protections to protect it. But as the last point points out, the most important thing here on this slide, your takeaway is you got to know what you have. It's really critical.
Yeah, and that's preventing misappropriation really just does start with that point of knowing what it is that you have that you need to protect. And whether that takes the form, as Brian suggested, of formally indexing all of your trade secrets or not. If you have to think about what works best for your organization in your particular situation. But what you do need to know is what it is that you have, and think about how you go about protecting it given your particular situation. And whatever that situation is, preventing misappropriation really starts with the appropriate culture, and making sure that there is a culture of recognition and protection of the company assets, particularly trade secrets, when those sometimes can be the most valuable asset that the company has. Your whole business might be built around your trade secret. That starts with management buy-in. That starts with top-down leadership and employee education. So it makes sense, and we would suggest that if you don't already have formal training about what are our trade secrets, what do we do to protect them, what is the expected behavior, what is unacceptable behavior around the treatment of trade secrets. If you're not doing that already, you might want to do that. Presumably you have that stated in your employee handbook or your policies. If not, you should look into that as well. But we would suggest to you that you might want to go beyond that and put a seminar on about this is what we do. If we don't have this, we're done. We need you to make sure you abide and respect our confidentiality around these issues. So you can also, depending on what your materials are, you can label them. If it's something physical or you have a file, you can certainly restrict access to that. But if it's something or a product or what have you, you can certainly restrict access to that. More often than not, it's what you seek to protect is in an electronic form. So in some of the prior examples I gave would be the employee lists or the customer list or the customer list or the pricing formulations, things that tend to be in electronic format. But with those kinds of secrets, there are things you can do. You can limit your system access, for example. Your engineering team might not need access to the sales database, for example. If your system is configured such that any employee can get to anything, you might want to rethink that. The sales staff, on the flip side, might not need access to the engineering databases and lab notebooks and things like that. You can certainly restrict the likelihood or the risk associated of an exiting employee grabbing your trade secrets and walking out the door with them if those folks don't have access to those materials in the first instance, or at least if there's some kind of process, traceable process that they would need to go through in order to gain that access. Fleshing this out a little bit more, this is really the nuts and bolts and the blocking and tackling of preventing misappropriation. We mentioned confidentiality agreements. So that comes into play when you hire folks. It comes into play if you don't have these in place already. There are measures that you can take to implement confidentiality agreements and get folks to sign them. You can't just push it out there. You have to support them with consideration, and those are things that we can talk to lawyers about once specific plans get drawn up. Non-competition agreements, those are the agreements, for those who don't know, that say that if you work for me, if you leave, you can't go work for one of our competitors for a certain amount of time or in a certain geographic domain. Those can be very effective, but they're in decline in terms of judicial enforcement. There is a trend, and Brian and I have argued this on both sides of the issue, frankly. There is a trend judicially away from enforcing non-competition agreements. Some states don't allow them to be enforced at all. California is a great example of that. Other measures, thinking about your data security. That's even more important now with remote workforces, or workforces that are more remote now as a result of pandemic than they used to be. If you can access everything from home and you don't have to worry about somebody walking past your office and noticing that you're downloading something, maybe you're more likely to do that. So maybe what you should do as an organization is have some kind of system in place that will flag or alert the IT staff if someone is downloading a large volume of files or accessing a portion of the database that they don't ordinarily need to access. Similarly, think through those issues for your BYO policies. Folks who have their phones tied to the system. I want to talk a bit about what happens when employees leave, because as Brian mentioned earlier, more often than not, trade secret misappropriation takes the form of a departing employee or someone who hasn't even departed, taking the information and leaking it out and using it for some nefarious purpose. But more often, and most often, I should say, it comes into play when someone leaves for a competitor, like in my robotics case. What we would suggest that you think about is what protocols should be implemented when you know someone is leaving. If they surprise you, maybe there's not as much you can do about it. But when you know someone's leaving, it would be helpful for us as litigators if you had a system in place that would be tracing that person's download activity, that person's system activity, and would perhaps, again, as I mentioned a moment ago, flag it if it's unusual. What we would also suggest is that you hold off on recycling that person's laptop or wiping the laptop. You may not know when that person departs that person has already swiped your content. You may only find that out at some later point. But at that point, you're going to be calling your lawyers to see what you can do about it. And if we don't have the ability to trace that activity, if that person's server activity has been wiped, if that person's device itself has been wiped and recycled, and it's now being used by somebody in accounting for some other purpose, we are playing catch up. And so if you can think about that, just set those things aside, maybe have a cooling off preservation period, that would be helpful. All of these things are even more of an issue these days amidst this great resignation that we keep hearing about of folks leaving either for other jobs or for not another job. But what we have right now is certainly more employee mobility. It's an employees market. Folks can jump, and especially when they're going to jump to a competitor of your business, all of these issues are high risk situations.
One thing I'll add, just real quick, on the non-competition point, Eric is right that it's in judicial decline in certain states. I will tell you from my experience, in states where non-competition agreements are enforceable, it is helpful to have them if I'm litigating a trade secret case. I had a case where I did not have a non-competition agreement, and the other side and the judge beat us up a bit on saying, well, you're not entitled to as much discovery as, for instance, you want because you didn't have a non-competition agreement. The seriousness of our trade secret claim, as well as our efforts to protect it, were called into question in part because the client did not have a non-competition agreement in place in a situation where you would have expected one. So I just want to highlight that point, that even though the non-competition agreement itself may not be enforceable or subject to some limitations, the mere fact that you have one is a benefit for arguing that you have done what you needed to do to protect your trade secret.
Yeah, that's a great point. And before I move on to the next slide, I wanted to remind our participants that feel free to use that chat function to raise questions that you'd like us to address, and we'll work them in either as we speak or hold off till the end. So we talked a bit about how do you keep your trade secrets from walking out the door. We should also spend some time discussing how do you address the situation or the risk of other your competitors or other folks' trade secrets coming into your business, because that can make you a defendant in a lawsuit. And I think the single most important thing to do on this point is to make sure that your screening process for onboarding new employees is mindful and actually addresses the potential issue of incoming trade secrets. So particularly in a situation where you're hiring someone from a competitor, one should consider, am I hiring this person because of what he or she knows specific to that competitor? Or am I hiring that person because that person can bring information from the competitor that's going to help me compete? And if the answer is the latter, you're in a pretty high risk situation. And that's that's before you even think about whether or not that person is subject to a restrictive covenant, such as a non-compete. So what we recommend is that you have some kind of written acknowledgement from this onboarding person, the person that you are onboarding, that states that that person acknowledges that he or she is being hired for their qualifications, and not because that they are bringing any kind of information that belongs to someone else, and that they are not subject to any kind of restrictive covenant, and that they are not bringing anything from anywhere else. If you find yourself in a defense posture, will be much better situated if you can show that to the court if it gets to that point, or to the lawyers who would be representing your competitor and the former employer of your new employee in that situation. There's a reference here to inevitable disclosure. And that is a concept in trade secret litigation that whether or not one has a restrictive covenant, whether or not you have a non-compete, that there may not be a situation, there may not be a scenario where an employee can go work for a competitor and do that job without disclosing trade secrets that belong to the former employer, that disclosure would be inevitable. That is that is an evolving concept in trade secret law. There is some sentiment that the Defend Trade Secrets Act, the federal statute, was in part intended to do away with that concept, with the inevitable disclosure concept. And the statute itself does say that you can't keep somebody from working. However, if it is in fact true that there is no way that this person could do this job for the competitor without divulging the trade secrets of the former employer, that's an argument that we would certainly make in defending that interest. We mixed reception in courts these days, but just to make you aware, that is a concept that exists.
So now we're starting to migrate over to litigation. All right, we've talked a lot about what you can do up front to avoid it. But now we're getting into a circumstance where maybe you have not been able to avoid it. Maybe you've had an employee leave and they've taken a lot of your stuff, and some of that stuff or most of that stuff you believe includes a trade secret. Well, if you give one of us a call, or if your litigator a call, you're going to have the kind of conversation Eric referenced earlier in this presentation that he had with his potential client, whereby they talked about, well, is this really a trade secret? What did you do to protect what you are now claiming is a trade secret? It's imperative that you have that conversation before you press the litigation button. Another imperative question that you need to ask yourself and discuss is, okay, what's the harm that's going to be caused if we don't prevent this trade secret from being used out in the marketplace? That goes back to the point of having to value the trade secret, right? That's going to be a critical analysis. It's going to be a hard one to make early on, but it's going to be an important one to make. And, perfection does not need to be the enemy of the good here. You can just get a general sense of what the harm is. The last thing that you need to really think about, or at least one of the major things you have to really think about, is what's it going to cost to go to litigation, both with respect to if you are going to be the plaintiff bringing the case, but also let's say you've gotten sued or you've gotten a demand letter from somebody saying, hey, that employee you just hired has our trade secrets and you need to stop that employment and make sure that person returns the information and make sure you don't receive any of that information. You've got to do an analysis of whether or not you want to stand your ground and stay with that employee. You got to make an analysis if you're the plaintiff, whether or not you're going to go ahead and fight the fight. This litigation is expensive. And so it's something that you need to think through whether or not you're going to engage in it. I will tell you, among the business disputes that I've been engaged in, these routinely have an emotional component to it because we're talking about theft, right? Costs, and you got to think rationally when making the decision and control as best as possible the emotional component to it. So those are some of the things you need to think about right before or right at the time in which you may have gotten sued, if you've gotten sued.
And what I would add to that, particularly on the cost point, is that your business liability policy may very well have an exclusion, so no coverage available, either in terms of liability or in terms of defense costs you're paying your lawyers. There may not be any coverage available for alleged misappropriation of trade secrets. I have seen exclusions that speak not only to that, but really to any kind of intellectual property theft or misappropriation. So, typically what you do is you get sued and you send the notice of suit off to your agent or your broker, and you get a response from your insurer that says, we've received your claim and we're going to, we'll defend it. Maybe subject to a reservation of rights, but we'll defend it. What can very well happen in these situations is you get the letter back from the carrier stating you have this exclusion, no coverage is available. you're on your own. So that is a risk to assess.
So, this is just a real quick stat slide. The DTSA, that's a reference to the Defend Trade Secrets Act. That is a federal trade secret statute, which primarily has brought trade secret claims into federal court. It was passed in 2016. This stat demonstrates how many of the cases over the years, particularly in 2017 and then in 2020, have been filed overall using the DTSA and not using the DTSA. You see it's pretty steady. That's a pretty good number. Next slide. So I mentioned one of the benefits of the Defend Trade Secrets Act is it took cases into federal court. And why that matters, by the way, for us lawyers, generally speaking, the quality of the judges and the quality of the system is just a bit better in federal court for commercial cases. Obviously, there are exceptions depending on what state you're in, but that's generally my experience, at least. And so that's one of the benefits. The other benefit that the Defend Trade Secret Act provides is this point, and I'm not going to go through every single point here. However, the big point is that you have available as a tool, if you can meet the standard, which is a high standard, of ex parte seizure. What does that mean? It means you can go to a judge without the other side being there and say, hey, Your Honor, they stole our secret sauce. It's out in the marketplace, and we got to get it out of there ASAP, or we're going to lose the trade secret forever. There are, as you can see, this slide demonstrates a lot of hurdles you got to go over to get to that point, because I mean, imagine that you're getting in front of a judge without the other side being able to plead their case, and you're getting an order to take their stuff off the shelves. But that's a tool that's available under the DTSA, and it's an extremely powerful one if you can meet these standards.
And I would add to that. I mean, there are cases where Customs has seized containers at the port, product that's been manufactured as a result of misappropriating trade secrets. That is very rare. And where you would more likely see that happen is in the criminal arena, where it's not you bringing a lawsuit, but rather the U.S. Attorney's Office or the FBI, the Customs folks are investigating and driving that process. And you may have a follow-on civil lawsuit, but the ex parte seizure part more often than not gets handled by the authorities. What does get handled by the parties in a civil lawsuit, and Brian and I have done this many times, is an injunction. So at this point, let's say that you're a plaintiff. You would be a plaintiff. Your former employee has left your employment and has gone and is working for a competitor, and you think that you are at imminent risk of irreparable harm because you found out that this former employee on the way out the door downloaded what you consider to be trade secrets, your process information, your pricing, your customer list, what have you. One potential form of relief you can seek in conjunction with filing a lawsuit is injunctive relief. And an injunction is an order from a court that says, you, bad actor, need to stop doing what you're doing. You cannot use this information. You must return it, and it, various other things depending on your situation. That is not a gimme. It's not as difficult to get as the ex parte seizure that Brian discussed a moment ago, but it is a heavy lift. You have to show certain things here. You have to show that there has been misappropriation, or that there's imminent misappropriation, theft of your trade secret. And if you can show that, then the court can require affirmative actions. As I mentioned earlier, one of the limitations of the Defend Trade Secret Act is that you can't keep someone from working. You can't get an order from a court that says this person can't work for this employer. What you can do is get an order that limits certain activities or requires those affirmative actions to be taken to protect the trade secret. So what that sometimes means is you get an order that says that this engineer who has defected to the competitor cannot work on these kinds of projects, or this engineer cannot work in this capacity, but can work in consulting with the sales team, for example, or some other customized relief that would fit your situation. That is within the realm of potential injunctive relief if you can meet these proofs. As the last point here notes, it really depends on your situation. It really depends on the urgency of the threatened misappropriation and the form and the fashion in which it would take. So this litigation, when you're in litigation, they can be pretty intense. I write here that they burn hot, but they usually don't burn for very long. What I mean by that is that if you go into court, usually our clients, if they come to us because an employee has left and they suspect misappropriation, that's something that is a 4-alarm fire that needs to be put out, and drop everything and draft up the papers and run to court and try to get the injunction, assuming you think the circumstances warrant that. That's a lot of effort. It's pretty intense on the front end. Typically, if you can make these proofs and say you get your injunction or your temporary restraining order, which is essentially an injunction for a shorter duration, if you can make those proofs, typically what happens after that is the parties sit down and work out some kind of resolution as to how they can peacefully coexist going forward. And that's what I say when I say that it usually doesn't burn that long. Because typically their facts are such that it doesn't make sense for the litigation to continue. The decision points there are, do you proceed, with notice to your competitor who is now employing your former employee, or do you proceed ex parte, which essentially means you just go to court without notifying the other side, in which case the court is less likely to give you what you want. That's the risk you need to take. You take that risk if you think that taking the time to notify the other side is going to cause them to do things that you won't be able to fix down the line. You can get what expedited discovery meaning you can get orders to direct your adversary to provide documents or testify immediately or on a much shorter term than would ordinarily happen in a litigation. You can try to get an evidentiary hearing where you would try to make these proofs and get, if not a TRO, then a longer term injunction. You can try to do that in an expedited fashion. All of these things are possibilities depending on your situation. All of them are very time consuming and very expensive. And if you do get these kinds of restraining orders or injunctions, there is a requirement under the federal rules that you post a bond. And what a bond means is that if that injunction is eventually overturned, let's say we succeed in convincing the court that an injunction should issue, that you're likely to prove that there has been a misappropriation of trade secrets and all the other factors. But later on, as the case develops, it turns out that what we thought was a trade secret wasn't a trade secret at all. And the other side prevails. What will have happened in the meantime is if you got that injunction, that person has been wrongfully precluded from doing his or her job in the form or fashion in which he or she was hired to do it. A bond protects against that. And that's like 10%. It usually isn't a huge impediment. We have connections to get that lined up. That is something to keep in mind as you proceed.
Well, recognizing that we've got just a few minutes left and we want to keep the questions, I think, Eric, why don't we go to the last substantive slide, which is the one by damage award by industry.
Yep.
I'm going to go briefly through this. I thought this would be a helpful slide for everyone to see and end on. It breaks down the damages that have been awarded by industry, so you can see where by industry the risks exist. One of the slides that we have here that we skipped over, though, that's important that we can talk about here is just about damages. There's several different categories of damages that you will be available to a plaintiff. Actual damage. You've also got punitives, reasonable royalties. You've got also attorney's fees. With respect to punitives and attorney's fees, just know that you need to show willful misappropriation, which means you got to show that the bad actors knew what they were doing that was bad and did it anyway. That can also double your damages, double your actual damage that you can claim. So this is one of those cases where, while it's expensive to bring, if you got a real case, there's a real payout at the end. I mean, we're talking about bad actors typically when we're talking trade secret theft. And so that's something that you want to be mindful of. It's one of those where, again, as we mentioned, doing the due diligence on the front end will help you make the right decision on the back end. With that, we'll open it up to questions, and unless Eric has anything else to add to that.
No, so I'm looking at the chat. There's a excuse me. There's a question about consulting, whether we provide consulting, unpaid consulting, and yeah, I think ordinarily when a case comes in, we have these initial discussions. There are initial discussions that happen in order to just decide whether or not we're going to be representing you and whether it makes sense for us to represent you. And we don't charge for that. So initial discussions are not something that you pay for, within reason.
Yeah, and I add, if the question is as to consulting pre-litigation, we're happy to have that first conversation and we can discuss to what extent you need that consultation and what that would look like on a flat fee or some other form. So if you have questions on that, or if you want to ask, discuss that further, please reach out to us offline and we can connect.
So to answer the second question, yes, the deck will be made available, and both Eric and Brian's contact information is at the end of the slide deck. So you can reach out to them if you feel you want to connect with them. There's another question in the chat box. Eric or Brian, if an individual who steals the trade secret leaves the offending company, does that make a difference if the company continues to use that trade secret?
Yes, it does make a difference. You want to stop the misappropriation. And if someone brings a secret to me and then that person leaves, but I continue to use it, I'm still a defendant in a lawsuit. Misappropriation is not just the theft. Misappropriation is also the use of what was stolen without the right to use it.
Terrific. Thank you, Eric. I've got a question. A lot of our companies are doing work overseas, especially in life sciences. They have a tendency to go over to Europe, get a CE mark before they come to the FDA. Obviously, IT is by definition, boundaryless. How do you handle the complexity of dealing now with trade secrets in overseas markets, not just China, but just in general? And it's a big question, but I mean,
Yeah, wow. That could be another.
That's a whole other session, I know.
Right. So, well, take it at a very high level. You need to be mindful of what you are disclosing in support of your various applications in different jurisdictions. So I'll analogize that to like a patent application. So you may have a technology that you want to patent, or a device or other invention that you want to patent. And there are aspects, the trade-off with a patent is that you don't get, it's not a secret, it's published to the world, it's a patent, right? But there may be aspects of, so the device itself might be patented, but how you go about making the device, you might keep in the trade secret domain. But you would have to be careful in submitting your patent application that you're not giving up that secret in support of the patent application. Similar when you're dealing in other jurisdictions and other nations, you need to be mindful of what you are putting in terms of your submissions for various approvals, that you are not giving up what you would like to have protected as a secret here in the US. And then in terms of overseas misappropriation, that is a real mess. That really depends on where you're afraid of the misappropriation occurring. There are questions around, do you bring the litigation in the US, litigate it in the US, and then seek to enforce it overseas, or do you start the litigation overseas? It really depends on the jurisdictions in question.
I will only add to that, my general default, and obviously every situation you want to look at, is to get this defendant in the US and make sure there's money that that defendant has in the US that I can attach a judgment to. We've litigated overseas. My experience with the quality of the judicial system is not the same as the quality here in the US. And so my first question will be, is there a way for me to get this person in our backyard and make sure they have to pay in our backyard?
Great. All right. Well, I want to thank you both. We've reached roughly 11 o'clock, perfect timing. And I want to thank Eric and Brian and Fox Rothschild for the presentation. Kate has posted, yes, we will share the presentation. And again, Eric and Brian's contact information is at the end of the slides. We appreciate everybody participating and hope that this was valuable. And I want to thank, again, Fox Rothschild for taking the time for what's becoming an increasingly important topic for any technology company. So thanks, everybody, and have a great morning.
Thank you.
Thank you, everyone.